Yes, sir. Dr. James Eric McDonough. I'm the pro se plaintiff.
Hi, Sam Zestan from Weiss Serota for the defendant, City of Homestead.
Grant Stern, I'm a journalist. I asked Mrs. Singler for permission to record, but she never got back to me, so I would like to ask the court for permission to record today.
That's fine.
Thank you, Your Honor.
Emily Scott, court reporter from United Reporting.
Madam Court Reporter, this is the clerk. May I have your phone number, please?
The firm's number is 954 525
Okay.
2221.
2221. Thank you very much.
No problem.
All right, good afternoon to all of you.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
All right, Mr. Seskind. Is that how you pronounce your name, or Seskind?
Yes, Your Honor, Zestan.
Seskind?
Zestan, Your Honor.
Seskind, okay, got it. Make sure I was pronouncing it correctly. All right, so we're here on the writ of mandamus, which Dr. McDonough filed. Last week, and I'm sorry to have canceled on you, but I had a personal emergency that I couldn't be here, even if I wanted to be. So, but it's okay, because I really wanted an eventual hearing, and aside from wasting your time, I wanted to do that. Mr. Seskind, this is an order to show cause as to why I should not grant it. The giving of the records to the plaintiff. So
Correct, Your Honor.
the burden shifts to you.
Right, so thank you, Your Honor. As you pointed out, we are here on the alternative writ that you issued on April 27th, 2022. As a result, the only issue before the court today is whether or not a plaintiff is entitled to mandamus relief. Because it is undisputed that the city provided plaintiff with invoices requiring advance payment for the records he requested, and it's undisputed that he did not make any payments for those records, mandamus relief is not available. Florida law is clear on that point.
I don't disagree with that position. The problem I have, and that's why I asked for an evidentiary hearing, is are the charges reasonable? Dr. McDonough believes the charges are unreasonable.
Right, Your Honor, but the reasonableness is not appropriate for determination on mandamus. Dr. McDonough has filed separate counts within his complaint seeking declaratory relief, and his count 2 seeks a declaration regarding the reasonableness. So that is something that ultimately, will be determined in this matter, whether or not the invoices were reasonable. But in terms of mandamus relief, the question is, has the city responded?
The problem is that that's cat out of the bag issue. It's a circular issue. One is, are the invoices reasonable? If the invoices are unreasonable and you don't turn over the documents until he pays, if he pays, then and determine it's unreasonable, what's the remedy?
Well, Your Honor, he has other relief that he's seeking in his complaint. And the law doesn't state that if you challenge the reasonableness that you get to bypass the mandamus requirements. In fact, I think the law is pretty clear that if you haven't paid, mandamus isn't available. All that the court can compel the city to do is respond. It can't dictate how the city responds. And the city's response was that it provided the invoices. If the invoices are not paid, then mandamus cannot be available. And I can pull up, if Your Honor would like me to share the screen.
I know the law. The point I'm trying to make is that if the invoices are unreasonable, then he's entitled to a reasonable invoice, and he's entitled to the documents. I mean, the other option would be for me to grant the mandamus without the payment.
Well, no, Your Honor, I don't think that you can do that. I think the law allows the city. In fact, it says that the taxpayers aren't to bear the burden.
I don't disagree with you. I agree with you.
Well, Your Honor, we're talking about mandamus. So if in count 2, right, let's say that Your Honor denies mandamus relief because the invoice hasn't been paid, and we proceed with this matter, and as part of the declaratory relief, plaintiff, convinces the court that although obviously I do not agree with this point, but the plaintiff were to convince the court that the estimate was unreasonable, and then as part of that relief in a deck action, Your Honor could, say, well, the reasonable amount would be X, right? So that's something that is to be determined as part of count 2, as part of his deck relief. It is not, reasonableness is not before the court on mandamus, because that's not a ministerial function in terms of determining the reasonableness. The ministerial function is providing the response.
I understand your position. I think it's just a circular argument. But let me talk to Dr. McDonald and get an input from you.
Yes, sir, Your Honor. In the city's response, they noted how much I paid to file the case versus paying the fees that are allegedly refundable if they were excessive. I'd like to state I've paid over $4,500 to the city of Homestead getting responsive requests. In many requests, I've alleged they've excessively billed me. In other cases where we're litigating the same issue, city has claimed that 119 does not allow damages, and because of the voluntary payment doctrine that I voluntarily paid, I'm not entitled to any refund, even if they are to be. That's why I'm not paying them, and I decided to come here. Furthermore, Your Honor, I'd like to note that the case cited by city, in the exact section of the case cited by city, FACA v. Zuckerman, 221 SO 3D at 1263 stated that, quote, Florida courts have consistently held that where a service charge was warranted, an agency is authorized to require payment before producing the records, end quote. The key word in that passage, Your Honor, was warranted. And the courts have held that an excessive charge is not warranted and deters my rights from seeking records to which I'm entitled.
Mr. Seska, obviously you're not going to present any witnesses on this issue. So,
well, Your Honor, so the case goes on to state at page 1264, quote, a person who has not paid for the cost of production is not entitled to mandamus relief on a public records request. That's what the court in Zuckerman-Spader held. The third DCA has held that in the Nunez v. State case, which is 731 Southern 2nd 865. There, the third DCA denied a petition for writ of mandamus as moot, where the state had provided the requester with an invoice stating that he be provided copies upon payment. When payment wasn't made, the third DCA said mandamus relief isn't available. The third DCA followed that.
Dr. McDonald, you'll let him speak.
The third DCA followed that same principle in Alexis v. State at 732 Southern 2nd 46, denying a petition for mandamus, claiming that under the premise that a requester is not entitled to records free of charge. This circuit,
I don't disagree with that.
And this circuit, Your Honor, recently in the Stock and Con versus Miami-Dade College case, found this down this exact same line. It dealt with specifically whether mandamus relief was appropriate when the amounts invoice hadn't been paid, and not only did the circuit find that mandamus relief isn't available, but it also found that pursuing mandamus when you haven't paid the invoice is one of the factors that it considered in finding an improper purpose entitling the agency to fees.
I just want to make sure the record's clear. I don't disagree with your statements. I disagree with the fact that if the invoices are unreasonable, they have to be reasonable. I have to make a finding of reasonableness before I can determine whether I can issue the mandamus or not. I disagree with that. I know you disagree with that, but show me the case law that says that we don't get to determine the reasonableness of the invoices.
Well, Your Honor, because reasonableness is an entirely separate issue. Mandamus is only, and he has a cause of action directed at reasonableness. And mandamus is only available when there's no other available relief. It's an extraordinary writ.
Well,
It's one of the-
let me ask you, what's his other relief?
He has a separate count regarding the reasonableness of the invoice. Count 2 of his complaint, which is not for mandamus relief, seeks a declaration regarding whether or not the city's invoice is reasonable. If he were to prevail on that count, then he has the relief available to him here regarding reasonableness. It's just a question of whether mandamus is appropriate, and mandamus isn't appropriate when you haven't paid, because there's no ministerial act to compel the city to perform. Your Honor can't issue a mandamus order that compels the city to provide an invoice in a particular amount. All the court can do is.
I agree with you.
Right, but that's what Your Honor is considering at the moment.
No, that's not necessarily true. What's the reasonableness of the invoice? I'm not saying it's a specific amount. I'm just saying whether the city inflated the invoices at the time that it took to put those things together, and whether that it goes across the board.
Right, and that's what's at issue in count 2, Your Honor. So in terms of mandamus, all the court can do is issue the order and say, city, perform X. There's no oversight that continues over it, right? So if the order were to say, issue a reasonable invoice, there's no continuing oversight over that. So the city, let's say under that scenario, the city provides a new invoice with a different amount, then we're just going to be back here, if Dr. McDonough then contests that invoice and the reasonableness of that. Your Honor can't tell us what amount to put in mandamus. So the appropriate avenue to address that is in his declaratory relief count in count 2, where Your Honor can examine, how the invoice was prepared, what the amounts are, whether or not it's reasonable. And at that point, if Your Honor finds it's not reasonable, then he's got relief he's seeking in count 2 that would,
No, I got your argument with the second count. Dr. McDonough, you get the last word.
Yes, sir, Your Honor. With the cases cited by city, I agree, as you do, that if they provided me a reasonable invoice, I'm not required to pay. However, the cases they cited are differentiated from the facts at hand, and the fact that those cases did not address an excessive and unwarranted, unreasonable invoice. Second, while I might not have an absolute duty to any public record, I do believe I have an absolute right to all non-exempt public records, or the right to have a reasonable invoice provided to me. I'd also like to note that while a city claims that there's no oversight ongoing in mandamus, that is incorrect. I will give them that the law is clear that it cannot be indefinite oversight for an indefinite amount of time or an indeterminate amount of time, but Your Honor absolutely is allowed to remain over this case. For instance, under 119.11.2, if they're found to be ordered mandamus, it's required to be done in 48 hours. If they don't give it to me in 48 hours, is Mr. Zeskind claiming that I can't come back here and let you know that? That's absurd, Your Honor. I'm sorry. So with that's all I have, unless you want to hear more.
Let me ask Mr. Zeskind, what's that case? You have a case number for that 11th Circuit case that you mentioned?
So, yes, if Your Honor can give me 1 second. We filed it as our second notice of supplemental authority.
I didn't get that in court, ma'am.
Okay, I apologize for that, Your Honor. It should have. But the case number is 2021-005958. It was in section 30.
598?
Correct. 5958.
Do you know the judge of that other than the division?
Judge Riamberto Diaz.
Okay.
And I can have my office re-upload that if Your Honor.
No, that's all right.
Okay.
I'll get it myself.
It should have been included in our package.
Okay. All right. Gentlemen, I have to look into this a little further concerning the arguments of the city. I will send you a detailed order on this issue.
Okay.
Thank you so much, Your Honor.
Thank you.